Uncontested probate. Losing a loved one is one of the hardest experiences in life. While emotions run high, dealing with the estate they left behind can add stress. Luckily, if the estate is handled amicably, it may qualify for uncontested probate, which can ease the process for everyone involved. Uncontested probate ensures a smooth distribution of assets, avoiding court disputes and conflicts. Let's take a look at how uncontested probate works, the legal considerations involved, and how a skilled lawyer can help guide you through this process. In Texas, probate refers to the legal process of validating a deceased person's will and distributing their estate. This process can become complex, but when family members and beneficiaries agree on how the estate should be divided, it's called uncontested probate. This approach saves time, money, and emotional strain. Uncontested probate in Texas generally follows a defined process. An application for probate is filed in the Texas Probate Court in the county where the deceased person lived. A waiting period of 10 to 14 days follows to allow any stakeholders to contest the will. If no one comes forward, the court verifies the will's validity and either confirms the executor named in the will or appoints an administrator if none is specified. The executor or administrator is then tasked with collecting the deceased's assets, paying off debts, and distributing the remaining assets to the beneficiaries. Uncontested probate doesn't require prolonged court involvement, making it an efficient and cost-effective option. However, it still requires proper adherence to Texas laws and court guidelines. Legalities of uncontested probate in Texas. The type of probate administration used can impact how smoothly the process goes. In Texas, there are two primary types. Dependent probate administration involves close court supervision to ensure the estate is managed properly. The executor must get court approval for any significant actions, like selling property or paying debts. This type of administration is used when there's a risk of conflict among beneficiaries. Independent probate administration requires minimal court involvement. This option is often preferred for uncontested probate because it's faster and more flexible. The executor has more autonomy to carry out the necessary tasks without waiting for court approval at every step. For a probate to proceed independently, either the deceased must have specified it in their will, or all beneficiaries must agree to it. Independent probate saves time and reduces court fees, making it ideal for uncontested cases. Texas also offers a unique probate option called muniment of title, which allows property transfers directly to beneficiaries without appointing an executor. This is especially useful if the only remaining asset is real estate. How long does uncontested probate take in Texas? The timeline for uncontested probate in Texas can vary based on the complexity of the estate. Typically, uncontested probate cases can be completed in as little as 6 months to a year. Here's a breakdown of the major steps. Filing the application for probate. This must be done within 4 years of the decedent's death. Waiting period and notice posting. The court requires a waiting period of 10 to 14 days after filing to allow potential challengers to step forward. Court hearing. After the waiting period, the court will hold a hearing to confirm the validity of the will. Asset inventory and claims processing. The executor or administrator has 90 days to file an inventory of the estate's assets and pay any outstanding debts. If there are no disputes, the estate can be distributed to beneficiaries once debts and taxes are settled. Common issues that can turn uncontested probate into a contested case. While uncontested probate cases are smoother, there are instances when they can turn contentious. Here are some common triggers for probate litigation. Will revocation. Disputes may arise if someone claims that the will was revoked or is invalid. Lack of testamentary capacity. If someone argues that the deceased didn't have the mental capacity to draft the will, it could lead to a court dispute. Undue influence. Claims that the deceased was coerced into making certain decisions in the will. Improper execution. A will that wasn't signed or witnessed properly can be challenged. Fraud or mistake. Allegations that the will was tampered with or contains errors. If a probate case becomes contested, it's crucial to work with an attorney to navigate the legal proceedings and protect your interests. What does an uncontested probate lawyer do? Even if a probate case isn't contested, having a lawyer is important to ensure that everything is handled correctly. An uncontested probate attorney can help ensure compliance with Texas probate laws, prepare and file all necessary court documents, assist the executor or administrator in managing assets, protect the rights of beneficiaries and heirs. If you're an executor or a beneficiary involved in a probate case, a lawyer will ensure the process is as efficient and stress-free as possible. The law office of Whitney L. Thompson, PLLC, has extensive experience in handling uncontested probate cases in Houston. Their attorneys can guide you through each step of the process and ensure that the estate is distributed according to the decedent's wishes. For more information, or to schedule a consultation, contact the law office of Whitney L. Thompson, PLLC at 281-214-0173 or visit their office at 4201 FM 1960 Road West, Suite 360, Houston, Texas, 77068, United States.